This is the second video screenshot for weeks 3 to 4 in the Intro to Paralegal course. We're going to be talking about two rules that lawyers must follow in the state of New York that I consider to be highly relevant to the paralegal job. And then we're going to take a look at some practical considerations that I believe help paralegals avoid a rule we've already identified, which is that a person can't practice law without a license to practice law. And paralegals have a little bit of a dilemma because they're working shoulder to shoulder with lawyers, but nevertheless, because paralegals are not licensed attorneys, they can't practice law. More of that a little bit later. But the first rule that lawyers must follow that is one that paralegals need to be very much aware of is the duty of confidentiality. And first of all, as best practices, lawyers and their staff really need to protect the confidentiality of information applicable to a client. I think the safest rule is to say nothing outside the office that would tend to disclose the identity of a client. I could talk about a case maybe that I participated in years ago, or some matter of representation, and if I doctor enough facts about it, no one's going to be able to trace it back to the identity of the client. One of the points that I want to make is regarding confidential information is that it covers more than material connected with the attorney-client privilege. And let me get it up here. Yes. We could have information that is outside the attorney-client privilege that might be reasonably considered embarrassing to the client or detrimental to the client, and that creates a situation where a reasonable person might consider it to be embarrassing. Maybe we don't. I think we live in an age now where this is my observation with the social media disclosures that people make that I find to be kind of crazy sometimes. But the person who we're dealing with may have a greater sense of privacy. We old people, I think, do. And I'll give you one quick example. I consider it to be a very private piece of information regarding how much I may pay for a piece of real estate. I don't think it's anybody's business. However, that's a matter of public record if you really wanted to trace it down. And my point is, even if it's a matter of public record, it still could be considered confidential. And I would be very upset if a lawyer representing me in a real estate transaction left the office and went out to dinner that night and said to people, this guy, meaning me, just bought a house for so much money, etc. I would consider that to be violating the duty of confidentiality. And there's a business aspect to this, which would be that lawyer would never see another piece of business from me. I would never ask that lawyer to represent me again. The lawyer might say, it doesn't bother me that I don't get your business again, but you can imagine if I were a good client, if I owned a business, that I was a source of a lot of income to the lawyer's office. So again, I think the safest thing in this duty of confidentiality is just don't talk about what's going on in the law office in any way that would disclose the identity of the client. I have more detailed information, but that's kind of a takeaway. A second rule that's imposed on lawyers that paralegals need to be concerned about are the conflict of interest rules. And as you'll see here, it's the conflict of interest rules as they apply to former clients that should be of possible concern to a paralegal. And here's the deal. If I'm representing as a lawyer a client, and on the other side of the case, if it's a litigated matter, is someone I've represented in the past, it's possible that I have learned confidential information from that person that I could now exploit on behalf of my client in the present case. So one has to be very, very careful about that. And you can see how this could come about if lawyers or paralegals are moving, as they often do, from one law office to another. That's not the only way it can come up, but it can certainly come up in that way. So a paralegal who's working on a case, and I have an example here. A paralegal working on a case in law office A, who then takes employment in law office B, especially again if this is a litigation paralegal, has to be very careful that in the new law office, the paralegal isn't working on cases where the party on the other side was represented by the law firm that the paralegal used to work for. And the deal is there, the paralegal is going to make full disclosure, and then the new employer can figure out if there's a conflict of interest or whether disclosures have to be made, and so on. By the way, when sometimes the way to handle that is if you've moved to a new office and there's a piece of litigation involving a client from the old office, is you keep the lawyer or perhaps the paralegal segregated from the file. In the old days, that was easier because we had physical files, and we used to call that process building a Chinese wall. And today, of course, so much of the information that we're using is digital, but that would mean maybe it would be easier. It would mean putting the information in password-protected files and keeping the password away from the lawyer who we're keeping away from the file, or the paralegal we're keeping away from the file. I then have some what I consider to be practical observations about what is a paralegal going to be doing to make certain that no one is going to conclude that the paralegal working in a law office is actually practicing law. And one tip is to avoid being perceived as a lawyer. Some of you might think, well, that would be a good thing anyways, but to simply identify yourself however your office is going to refer to paralegals. Most offices refer to paralegals as paralegals. In some offices, they're called legal assistants, but by reminding the person on the other end of the communication outside the office that you're a paralegal is going to certainly avoid the situation where one thinks you may be a lawyer because you're calling from the XYZ law office. Next deal, never give legal advice. Certainly the paralegal can impart factual information and instruction, but they should make it clear that, or you, if it's you, that the source of any legal advice that might be in the instruction is from the attorney and not the paralegal. So I know over the years I've had an assistant call a client, and then that call would be Collins's, ask me to tell you to, and it's very clear then that the assistant is not giving legal advice, that it is coming from me. Paralegals author or create, if you will, all kinds of legal documents, not just in litigation, but also in transactions like real estate deals. and the paralegal needs to be certain that there's a process where the attorney in some way or another is approving the document before it is used. Offices work that out in different ways. If it's a volume office with routine documents, I am not suggesting that every document has to be eyeballed by an attorney, but there certainly has to be a process in place so the attorney can say that she knows, he knows that these are the documents that the paralegal has created. If the document isn't a boilerplate document, but it's a litigation document, I'm going to suggest that an attorney needs to eyeball that document before it is used. And let me just end with a general conclusion that I don't think I've offered, or general observation better, that I haven't offered yet, and that is lawyers have a duty to provide reasonable supervision over paralegals and their employment. And I think sometimes paralegals can help the attorneys with that reasonable supervision by making certain, again, that there's processes in place. I'm not suggesting that a paralegal should be pestering anybody. Look at this, look at that. Certainly one of the reasons paralegals are so valuable is that it frees up attorney time to do other things. But to collaborate with the lawyer about how should we have a process where these documents are reviewed, generally or specifically as the case may be by the lawyer, I think is something that the paralegal should be mindful of, and perhaps even make some creative suggestions, because we're still dealing with a situation where attorneys aren't always well versed on what it means to be working with a paralegal, at least in the legal environment, as opposed to simply getting work out. What could sometimes happen, and this is I know has happened a few times, the employing attorney stops working as a lawyer. It's a small office or a solo practitioner, and there's an illness or there's some kind of a breakdown. And what you can't do as a paralegal is find yourself trying to run an office where the lawyer is not available. Or inevitably, if that happens, you're going to start practicing law without a license because you're going to start giving legal advice. So I encourage you very much, if you think you're in that kind of situation, that you should seek, call a paralegal as a friend or whatever, make certain that your observations are correct, and then get out of that situation, because nothing good is going to come from it. Okay, so this will end this second screenshot. It was a little bit jumpy because I'm in my office now and there's been some incoming. But if you've got any questions, again, I encourage you very much to just send me an email at collins@ecc.edu, and I'll do my best to get back to you within a day. Thanks.